Good evening. Today we are going to discuss about the doctrine of basic structure, as I told in the previous video. So let us see what is the doctrine of basic structure. So why it is in news? Because a recent Supreme Court bench, which was constituted to review the 103rd Constitutional Amendment Act. You must be knowing what is this 103rd Constitutional Amendment Act. It is about EWS. This bench is looking into the aspects whether this EWS is violating the basic structure of the constitution or not, and whether it is constitutionally valid or not. So in this context, let us try to understand what is this doctrine of basic structure. So we must be knowing that doctrine of basic structure is not mentioned in the constitution, and it was a judicial invention, and it happened in the case. Keshavananda Bharati case was of 1973. So what is this doctrine of basic structure? It says that no amendment of constitution is permissible if it alters the basic structure or framework of the constitution. That means it says that our Indian constitution has something which is intrinsic, which is basic to it, and it cannot be altered. So some deeper philosophy of the constitution which cannot be altered. So this was the doctrine of basic structure, and based upon this, the Supreme Court can review and strike down any constitutional amendment which is enacted by the Parliament which alters the basic structure. So this way, Supreme Court has acquired immense power in reviewing the amendments to the Constitution. So the basic structure is a tool or judicial innovation. As I told, it's not mentioned in the Constitution, and it is an innovation of the judiciary to ensure that the legislature does not abuse the power given in the Article 368. What is Article 368? It is the power of Parliament to amend the Constitution. So under this Article 368, the Constitution may alter the whole Constitution altogether. But as now we have the doctrine of basic structure, it cannot alter the Constitution beyond a certain point. It can alter only to an extent where the basic structure is not altered. So this is the basic structure doctrine. Let us examine the other aspects of this basic structure doctrine. What are the components? Can you say that this is the basic structure, like Indian constitution? What are the components of the basic structure? No, we can't, because judiciary has kept it open-ended, and time and again it has said that it will be determined only on the case basis rather than having a strict basic structure boundary. So far we have seen many other things, like Supreme Court has declared secularism as a part of basic structure. Supreme Court has declared federalism as a part of basic structure. It has declared parliamentary system as a part of basic structure. So in various cases it has said that these things are part of basic structure, but nowhere it is written or clearly defined what the basic structure is, and it is left open to the interpretation of the judiciary. So do you think this basic structure is good for our constitution? It has both. It is both. Like, it is both good and bad. So let us first see its significance. What is the significance of this basic structure doctrine? It helps us to discover the intent of constitution makers. So every text written, it can be interpreted in many ways. So but in basic structure doctrine, it is helping us to determine the intention of the constitution makers. Rather than going just by the text, we are trying to get into the deeper meaning of the text and understanding the intent of the constitution makers. So apart from this significance, it also has a another significance, that whenever the parliament has a majority, the parliament is limited by this basic structure doctrine. Otherwise, the parliament would have amended the whole constitution, and maybe the something good or bad would have been added beyond, which is beyond the scope of the constitution. So this basic structure doctrine, it prevents the parliament from abusing its power. But that doesn't mean that whatever parliament is making is wrong. It's both ways. Like every organ of government, it has its own limitations and it has its own powers. And the other significance of this doctrine of basic structure is it protects our fundamental rights against arbitrariness, authoritarianism, etc., and it strengthens the cause of democracy. But let us see the challenges. See, the basic part of the democracy today we have, it is it it is the basic structure doctrine is inconsistent with the principle of separation of powers, which was given by Montesquieu. So this separation of powers says that no organ of a government should overtake or should eclipse itself onto the other organs of the government. So if there is parliament, the three organs of Indian government are parliament, executive, and judiciary. So each organ should work in its own sphere, and it should not overtake the other organs. So it should not eclipse onto the other organs. Neither judiciary should encroach into the powers of executive, nor parliament should encroach into the powers of executive, nor executive should encroach onto the powers of parliament. So if this basic structure, separation of powers, is maintained, then the government will can function smoothly, and the problem of encroachment of powers into each other will not happen. But with this basic structure doctrine, the encroachment into the powers of parliament by the judiciary has started. So this unless the we can't say the judiciary, we can't be sure of misuse, like we can't be sure of any one organ that it won't misuse its power. Tomorrow someday a time may come where the constitutional power guaranteed to the Supreme Court may be abused by one or the other person or the institution, because it's all open-ended. We are all humans, and humans are bound to commit errors. So we cannot put our total trust onto any one organ, but it should always be between the balance of organs. Like one should check one organ of the parliament, one organ of the government should check the other organ of the government. If parliament is encroaching into the powers of others, then Supreme Court should put a check on it and make the balance of powers equation valid again. So this is one challenge with the basic structure doctrine. And other challenge is vagueness. Tomorrow Supreme Court can innovate anything, and it can say that this is the part of basic structure, because it is not clearly defined, it's nowhere written. And it can also serve their political ambitions, because every human being is bound by some kind of ambitions, and we can't say that it cannot be abused or it cannot be used for some personal purposes. So what is the final conclusion? That it does not provide a technical solution. The technical solution should be like it should be amendment, like basic structure should be clearly defined, and it should be it should not be vague. It should be clear and clean. So that is the challenges with the basic structure. Now let us see what are the other doctrines of the Supreme Court. The first doctrine is doctrine of pith and substance, which says that if the substance of legislation falls within a legislature's lawful power, the legislature does not become unconstitutional just because it impacts an issue beyond its area of authority. Suppose a constitution, a law is made by the state legislature which encroaches upon the law of union list. So how can we say that the law, how can we determine this? For this we use the doctrine of pith and substance. In this doctrine, we, rather than going by the text, we go into the substance and we see the objective of the law. Rather than just going by text, we go for the objective, go for its application, and we also examine the uses, and then we conclude that whether this law is encroaching or not. So this determining the law, the correctfulness of a law by examining its objective applicability and other things, is the doctrine of pith and substance. What is doctrine of severability? Suppose a new law is made by parliament tomorrow, and some provisions of it are encroaching upon the fundamental rights of the citizens. So can we say that the whole law will be unconstitutional? No, because we have the doctrine of severability. The doctrine of severability says that only that part of the law which is inconsistent with the fundamental rights will only be invalid. If there are 10 parts in the law and only the part 3 is inconsistent with the fundamental rights, then we will only delete the part 3 but not the whole text. We'll keep the whole law and without part 3. That's it. This is the doctrine of severability. So it's clear now. The other thing is doctrine of eclipse. Doctrine of eclipse says that any law, as we have seen, there are 10 parts in the law, and only part 3 of that law is inconsistent, then this law will not be totally invalid. Rather, it will be eclipsed by the fundamental rights, which means that tomorrow if some amendment happened to fundamental rights and fundamental rights are now consistent with this law, then this law will become valid again. The law which was invalidated earlier, now this will become valid, because the fundamental rights which were amended are no more encroaching upon or no more inconsistent with this part 3 of that law. So with this, the doctrine of eclipse says that no law will be totally deleted, but it will only be eclipsed by the fundamental rights. As long as there are fundamental rights, this law will be inconsistent. Once the fundamental rights are suitably amended, then this law will become active again. So this is the doctrine of eclipse. The next doctrine is doctrine of flashes. Next doctrine is doctrine of flashes. Doctrine of flashes says that the court will protect the rights of only those people who approach the court for its protection, and not of the people who sleep at home and say that the Supreme Court will take care of their rights. So Supreme Court is there to protect. So according to this doctrine, only the rights of the citizens who are aware of their rights, they will be protected, and who are unaware of their rights, they should get aware, and it's upon them to be to approach the courts. So this is the doctrine of Flashes. Then the next doctrine is doctrine of territorial nexus. According to this doctrine, suppose a citizen of India who has renounced his citizenship and went to other country cannot say that I am no more an Indian citizen, so Indian laws will not apply to me. As long as there is territorial nexus with that person, the Indian laws, they are very much applicable, and the person is very much liable according to Indian laws. So if the person has run over to the other country and says that I am no more an offender, that will not be possible, and according to doctrine of territorial nexus, that person will be punished under Indian laws. The next thing is doctrine of culpable legislation. This doctrine says that what you cannot do directly, you cannot do it indirectly also. So you cannot mask something and say that I am not encroaching upon to, I have nowhere mentioned this topic, so I am not doing it. So this says that what you cannot do directly. Suppose a state government cannot make laws on union subject, but if it tries to do it indirectly, then even that law will be invalidated, and it will be inconsistent. So this is what the doctrine of culpable legislation is. And the last doctrine is doctrine of harmonious construction, which says that if two laws are in conflict with each other, then these laws should be interpreted in such a way that they'll not be in conflict, but they'll be in sync with each other. So whenever the interpretation is going against each other, then that interpretation will be inconsistent, invalid, and the interpretation which is in sync with the other laws, that only will be validated, rather than the other interpretations which are inconsistent with the other laws. So this is about all the doctrines. So this is it. Tomorrow I will come up with other topics also. Till then, bye. Please keep like, share, subscribe. Thank you.